So we have regional diversity. It's always fascinating, isn't it, when you come into a room and look where people sit. I make no comments about the studies that have been done on that and whether you sit on the back or the side or the front or whatever. It's whatever suits you best, isn't it? All right. Shall we get a crack on? So we worked out that from our quick survey, we all sort of know a bit about trusts, yep? And are you here because your bosses or whatever have forced you to come here and say, guys, you've got to get some more information about trusts, or is it simply because you want to become members of STEP, or what's your motivating force there?
I think it's such a state of flux. It's good to sort of revisit and see what I guess the safety in numbers, the contemporary views from people who obviously have great experience and expertise, sort of see what's happening. So.
And do you guys attend all like the cradle to grave type conferences and all those sorts of trust conferences and things like that?
Far too expensive.
Yeah.
They are, aren't they?
They are horribly expensive.
They are, and I think that's the one problem. But I think your comment about seeing what's happening in the area of practice is a good one. But how on earth do you keep up with it? Because it's those conferences are a day or two out of the office, and who's doing your work while you're not there, and the cost. It's a retrograde step, isn't it, in a way? So this is all right because it's your weekend, it's your own time.
But this course is really practical. We were just walking up the road talking about that. Chris and I did two of the papers last year, and it's really practical. It's really helpful.
Right.
So I've really.
So what are your names? You're Chris.
Chris.
And I'm
What's your last name?
Hellos.
Okay, and.
Barbara Delaney.
Oh, okay, right. Because I've seen some of your papers before.
Oh, right.
Because being on the committee,
Yes.
of course, I've been developing this all the way through. Oh, absolutely, absolutely. Well, the fact you're still here, you've been passing,
Yes,
and reasonably well from memory. I've done this part, and then I don't present in 2 or 3, but I'm in part 4 as well, which is for God's sake, the accounting side of things. How the hell does it work that a trust lawyer ends up doing a paper on accounting?
That's what I said to Chris. I didn't want to be an accountant.
No, but fortunately, when you're doing that too, aren't you?
No, Chris is. I had planned to.
Yeah. So that means we get to see you again at the end of April with the next workshop, and I'm the last day there, and I'm doing stuff about a trust lawyer's perspective of accounts and things like that. So again, trying to give it a practical view. And what we're trying to achieve with this whole course is indeed give a practical approach to trusts, which means for a lot of you this is going to be deadly boring because you hopefully know the basics of what we're talking about. And my part today, the anatomy of a trust deed, again, probably boring because you all know your firm's precedents, but hopefully there'll be a few little things here that make you think, is that the right clause, or is that the right clause I use for this? So hopefully you'll take something from it today.
A lot of the stuff we're doing at the moment is disestablishing trusts,
Yep.
resettling other stuff from crappy, old, useless trust deeds that have really poor clauses.
Yes.
And you just work your head against the table and go, who would draft something like this?
The
In hindsight, it's always good in hindsight.
Well, it's an interesting comment because I think for a long time trusts have been seen as easy money. Oh, just crank out a trust deed, push a few buttons and there you go. And that's been endemic, I think, in the practice of both lawyers and accountants for a long time. And now we're starting to find the problems that arise with that sort of relaxed approach to drafting. And quite often it's not just the expertise isn't so much in just the drafting of the trust deed, but actually extracting the information from the client in the first place to understand what are their circumstances and what do you need to do. And sometimes you'll interview a client for an hour and say, actually, no, you don't need a trust, it's no good, it won't help you. Other times it'll be, well, you need a trust plus this plus that. And these days it's usually a proper relationships agreement first, and then, well, maybe a trust. And then you've got, as you said, the disestablishment aspect. I got an email from the Law Society last week saying, oh, Simon, do you know a good trust lawyer in Auckland who could present on this topic? And I thought, oh, that's a cunning way of asking me to present a topic on disestablishment of trusts. But that's quite a common feature these days. And I think it'll become a lot more common if this Trusts Act comes in, because I'm a cynical old bastard these days. I'm past this sort of, oh yeah, law is great and let's help the world. I've become cynical. And my view of this Trusts Act, although it's been promoted as trying to say, oh, it'll help to clarify things and in effect codify things, although it's not a code, and make it easy for people to understand, to me, one of the essences of this, or the insidious sides of this act, is it'll make it so easy for beneficiaries to get trustees up before the court. One of the aspects, in addition to that, is going to be the mandatory disclosure of trust information and existence to beneficiaries. And if you combine that with our current social moray of entitlement, you're going to get children who are saying, oh, there's a trust, I want my money. And there'll be lawyers out there, and usually they're litigation lawyers, and I don't want to taint them unfairly, but I do, who will say, oh, well, yeah, we'll have a crack at this. And I know, and sometimes they don't know enough about trust law to understand what the story is, and they'll issue proceedings, and they'll start all this money go round, only get to court or find out or settle beforehand, oh, we haven't got a chance of winning here, let's just settle. And it's a nuisance factor. So I think there will be a whole raft of business arising from this Trusts Act simply because of ignorance by a lot of lawyers who should be here listening to these things about trust and understanding what's involved, but they don't do it. And that's often the way with those seminars and those conferences. The people who go are the diligent ones who try to keep up with current trends, whereas there are so many cowboys out there who just shoot from the hip. But that's one of the things about STEP, is that once you get your little tick, there's, I think, an increasing acceptance of the credibility that gives to you, that you actually know a bit about trusts. And hopefully in time that will build to say that if you haven't got a STEP credential, maybe you're not an up-to-speed trust lawyer, and that might help to weed some things out. So
with the indemnity insurers, increasingly they're sort of saying, unless you can absolutely, hand on heart say it's your area, don't do it.
Oh, absolutely. But you balance that with the fact that people say, oh, it's law, yeah, I can do it. And a lot of practitioners will say, oh, I've got the old precedent that I used to use, I'll just change a few names and that's good for my fees. I don't want to give it away to somebody else. And that's the constant, the give and take that you have. So hopefully it'll be the public that will start to sort that out when they understand that STEP is a pretty worldwide institution now, growing in numbers quite dramatically. And the reason why you're having to go through this arduous process of going through this diploma is because it used to be you could get admitted to STEP by experience base. You could be grandfathered in if you said, oh, I've got 5 years experience with trusts, that was enough to get you in. But even people then were sneaking in, because doing 2 trusts a year over 5 years doesn't really, to me, constitute being familiar with trust law. And so the idea was to get the numbers up, to get a bit of momentum, and then start to really kick in with the credentials, which is why you're here today. So let's have a look, the anatomy of a trust deed. What you'll find today is that I have a lot of pictures that might either be quite obtuse or have no bearing at all, but there is always a deep meaning to it. And with a picture worth 1,000 words, one of these pictures will hopefully resonate and remind you of something. So obviously we're talking anatomy of a trust deed. What makes a trust deed and what makes it tick? I think first of all we have to look at the types of trust, and given the vast audience that we've got here today, it would seem that the majority of practices in the field of domestic trusts, would that be fair to say? And of those, mostly they would be discretionary family trusts. Perpetual, you'll probably do some life interest trusts and some will trusts and things like that as well, as will others of us. But life interest trusts, usually created under a will, aren't as prevalent as they used to be, because I think trusts have taken over. But we still have them. We have the historical legacy of lots of those sorts of trusts and estates still going on. Then I want to touch on the dispositive versus the administrative powers. So it's important I put that, because that's a technical thing, and I need to let you know early on there are some technical aspects to what we're doing. We'll cover on after that with the legislative influences. Then we'll have a look at the trust deed and then a bit of a summary. So let's kick on. So types of trusts. Domestic trust, usual one. And the generic nuclear trust, mum, dad, children. Although, interestingly, I think these days there is no such thing as the uniform generic trust, because there is no normal family anymore. Are you all seeing a lot of blended families coming into your practice these days? Either because it's the Brady Bunch scenario. Some of you aren't old enough to know what the Brady Bunch is, but you know, the blending of families where 3 children from one family, 3 from the other all together, and then it's all happy as Larry while the parents are alive, and then when one of the parents dies or loses capacity, it's the capacity for World War III. It's a bit Trump-like with Syria, isn't it? You fire a few missiles and see what happens. And so I think there's a lot more of that happening these days, which means that as trust lawyers, we have to have a lot more, I think, care as to what we do, because things have changed and the old precedents aren't what they used to be. And it's that important aspect of when you start out extracting the information. And sometimes it's not what the clients tell you that's important, it's what they don't tell you. Or, because of our experience, what they don't know will happen. And I think that's one of the bigger things. A lot of people say, oh, no, my children would never do that. They all get on so well with my new partner and we're like just one big happy family. And I can tell them, look, that's fine, but in 5 years' time, with one of you gone, it's going to be a different ballpark. And some of them can't accept that, but that's part of what we have to do in analysing those aspects. International trusts, we all know about the Panama Papers and all that sort of stuff. Big industry, flies under the radar, great industry, best clients you'll ever get, because you never meet them. Perfect. But we're not here to talk about that today. We'll just wait to see what government rules do on that one. Charitable trusts, do any of you do much charitable trust work? Well, anybody who's a principal in a firm will find that most clients are 50% charitable because they decide whether or not to pay you, and you do the work for them, and getting paid is a different story. Which is the reality, but different story, but this is the pure charitable trusts. And interestingly, I gave a presentation, just a brief one on Friday, to the Retirement Villages Association, and my brief was for 15 minutes to talk about the update on the Charities Commission in the context of charitable trust retirement villages. And that's a really hard thing to do in 15 minutes. And I touched more on some basic principles, because these people aren't lawyers or accountants, they're just people in business trying to run a business based on a charitable trust. And I don't know how familiar you are with charitable trust law at the moment, but there's some, you may have done charitable trust with David McClay, the XRB, the external reporting, the new specific personal performance statements or something. Again, putting on my cynical hat, what's happened is that you used to just have to file your annual returns and do your usual generally accepted accounting principle statements and things like that. There's a new aspect to it where you have to set out basically your mission statement, what you're doing, how you've done it, why you've done it, and when you've done it. And to me, it's almost like an entrapment, because what's happening is trusts or charitable trusts will write down those things. This is what we've done, this is what we're trying to achieve, and it will be committed to paper. And then in time, there's going to be an audit of some sort, because you don't put these regulations in place without there being an audit for some reason. And my view is that if the government wants an audit at some stage, why would that be? Perhaps to increase the tax take. And they'll look at these things, and then they'll go back and look at the original trust deed and say, what was it formed for? What was its original purpose? Actually, what you were formed for 20 years ago is quite different from what you're doing now. You were granted charitable status on those original purposes. You've changed from that. Therefore, for the last 15 years, you weren't entitled to your charitable status, and we're going to ping you for it. And because trustees of a charitable trust, and all trusts have a personal and unlimited liability, there's the risk that each trustee will be liable. And so, to me, I reminded people they've got to go back to their basic principles. You've got to work on your business. So you've got to make your business successful. And there was somebody else talking about, you know, all the strategies and business strategies and how you run it and things like that. But you've got to keep going back to the basics. What is the reason we're here? What is our brief? And if our purpose has changed, can we change that? Do we need to change it? Do we need to go to the High Court to change it? Those sorts of things. So it's back to the basics, which is back to your trust deed. So charitable trusts, I think, watch this space. I think there could be a lot of stuff happening there in time to come. And then there are the managed investments trusts, the superannuation funds and things like that. Not touching on that, not my area. I think Juliet Moses, who's one of the lecturers, she does a lot of superannuation trust work. That's more her area. My area is the other stuff. It'll work if I point it to there. There's always a habit of that you get these pointers and you want to point at the screen and change it, and it doesn't. So you go here like this. So let's have a look. again, I'm conscious I'm preaching to the converted, but for a lot of lay people, they don't understand the differences between a family trust or a discretionary trust. And you say to them, you've got a discretionary trust. Oh, no, I've got a family trust. Or they think they've got to have the word family trust in the name of the trust. It's quite bizarre. And sometimes we deal with these things so often we don't understand how much we know and how little our clients know. A great example, I gave a client a report the other day. These are, for the last 10 years, this is what the trust's done, and here are all your documents and your contracting out agreements and your variations and whatever. And this property has now been transferred across and resettled and transacted, and it's subject to a bank mortgage. And I got this call and he said, I thought we'd sorted all the bank stuff out. And I said, yeah, we have. He said, but you said it's subject to a bank mortgage. I said, yes, that's right. He said, but we've done all the settlement. We've signed the papers. It's all been done. I said, that's correct. It means there is a mortgage over the property. Oh, I get it now. Because his partner was in his ear like that, saying, why hasn't this been done and what's happening? And he didn't understand, although we've told him for the last 10 years, it's subject to a bank mortgage. That's simple terminology. And so part of what we have to do as trust lawyers to do it effectively is to explain in simple terms to clients what they're dealing with. And in fairness, a client will never understand the subtle nuances of a trust deed. That's our job. Our other job is to convey to the clients the general essence of what they're doing so that they at least have a practical understanding of how the trust works. We understand the technical stuff, and part of that is the way in which we explain it to them. So, pointing out to them, family trusts, discretionary trusts, they are one and the same. And then, of course, we have the various manners in which trusts can be created. Trust instrument or a will. So we can have testamentary trusts. Do many of you actually form substantial testamentary trusts within the will? Because most wills form a trust of some sort, and we all know that. A lot of clients don't know that what they've done is created a testamentary form of trust. But I've got one client at the moment who's widowed, very wealthy, husband did everything, she's sort of left with all this money and sort of not knowing what to do, and no direct family. And she's saying, I'd like to give a lot of it away to charity. And we said, look, the best way of doing that is actually to form a charitable trust, because there'll be a lot more flexibility and ability to deal with that. And she said, oh no, I just want to do it within my will because it'll be simpler. And it's very hard to get the concept that actually putting in place a testamentary trust under a will for charitable purposes, in a way you're doubling up, because we've got to have a will that will go for 20 pages to cover it all. And again, it's the art of explaining to clients what the score is. So understanding wills, trusts. A lot of clients you'll find still say, I've got a trust, so I don't need a will. You get that comment every now and then.
Often I think we find that we'll just, in that situation, we'll create an end-of-the-boss trust,
Yes.
leave it empty.
Yeah. Apart from the initial $10 settlement. Yeah, absolutely. No such thing as an empty trust. Yeah. No, exactly. So yeah, I call that like an inheritance planning trust, where it sits there as a dormant entity waiting to be funded when somebody passes away. And that's become quite popular these days as well for people who can't quite cross the chasm of not owning their assets during their lifetime. It becomes quite a popular thing. And going back to your question, or your comment about the disestablishing of trusts, what I'm finding is that a lot of people will have set up trusts for a particular purpose, usually creditor protection issues while they're in business. And they'll say, look, I've been retired for 10 years now. I'm not going to have any property relationship claims, either because I'm still married or I couldn't go through the hassle of retraining another spouse or partner if my wife or husband dies. So that's not an issue. And they say, I don't need a trust anymore. And then you say, well, tell me about your children. Oh, yes, I've got 3 children. How are they? Oh, yeah, 2 of them are really good. One of them spends his money all the time, or one of them is a drug addict, or one of them is an alcoholic, or one of them's good, but money goes through their fingers, or one of them's great, but they've got a rocky relationship. And I say, are you happy that when you die, that will crystallise that child's 1/3 share of the estate, and they will be entitled to receive that? And if they've got any issues at the time, be it relationship issues or creditor issues or substance abuse issues, that the funds will be available to them and could be subject to those sort of influences. No, not really. Why don't we keep the trust running? And it's an interesting concept that people's mindset changes, and the trust, that's one of the benefits of the 80-year term of the trust, is it can serve different generations for different purposes. I've been doing a trust for one of my partners, and the partner was saying, oh, I want the trust to come to an end when the survivor of me and my husband die. And I say, why? Oh, because we haven't got much. And I say, well, you've got a house that's worth a few $1 million or whatever. Oh, but it's not that much these days. And I've got 3 boys, and they could do with the money. I say, but what if they're going through issues at the time? Well, what do you mean? Oh, no, they can sort it out. And it's taken probably 6 months for the penny to drop. So actually, there are second generational issues here, and they can benefit. And gee whiz, we could resettle and have 3 separate trusts, 1 for each boy. Why would you be so compromising? Admittedly, she's a litigator, and that's one of the reasons. She needs to be here listening to these sorts of things to understand the bigger picture rather than the tunnelled vision aspect that litigators attack. So, you know, interestingly, there's more to this than meets the eye. And it's not just trust lawyers who should be understanding these things. It's actually all sorts of lawyers, because it transcends all fields of practice these days. Like that cancerous Property Relationships Act, that transcends everything we do. And to practice in this area without giving that any credence is just it's a dangerous thing. So you can't really be a trust lawyer these days without understanding Property Relationships Act principles, commercial principles, property law principles, solvency, banking, all those sorts of things. Now this is interesting. I think it's to highlight that trusts take different shapes because all persons' circumstances are different. And so the left is the unusual shape. We'll have lots of different shapes of families and different shapes of trusts required, and those will change over time. As the sands of time run through the hourglass, so will the change of people's circumstances, which is why we need to make sure our trust deeds are robust but flexible. You will have seen probably a lot of trust deeds where they had their older trust deeds where their perpetuity period was 40 years from the date of settlement or something, and it tied in with basically the life expectancy of the settlor. And that gives us lots of problems these days because those trusts are coming to an end and there's not much choice you can do there. And you go back and think, why did people do it like that? And it's because they didn't understand, I think, the long-range abilities and benefits of trusts. I'm just trying to look here. Some of you won't have been in practice when we've had some significant changes to trust law. Early 90s, about 92, before 92, trusts were very limited in their application because we had estate and death duties in. And for those of you who don't know, it was 40% tax on estates 450,000 and more, and you couldn't have an interest in your trust. So for that reason, it was generally farming families who had trusts or the very wealthy, not the general mum and dad people. And then we had the 0 rating of estate duty. And then in 97, we had the repeal or abolition of estate duty. So that it wasn't just 0 rated, it was gone, it was opened up. And to me, that has changed the trust dynamic because it meant that we could then have a lot more trust and people weren't cut out of the scene because, in particular, a single person at that stage couldn't have a trust because they couldn't be a beneficiary because it would defeat their estate planning purposes. But once the estate duty nuance was gone, they could then become a beneficiary of their trust. And then when we had the PRA come in 1st of February 2002, it opened up the ability for all people in relationships, de factos, same-sex, people in couples, to form trusts for each other. And there's been a proliferation of trusts since then, especially since I think about 97, when the estate duty was repealed. And that was one of the national government's parting gestures before they handed across the reins of control to the Labor Party. So that change, I think, signified a big watershed mark in how trusts were perceived. And then we also had at that stage, I don't know if you recall, but there was surcharge for superannuitants. that if you earned income over a certain, I think it was about $65,000, there was a further 25% tax on excess income. And we also had the rest home subsidies. So, and at that stage, there were tax rate differentials as well. So we had lots of reasons where actually trusts could prove a lot of benefits in addition to asset protection. There are a lot of incidental benefits, a lot of tax savings, rest home subsidies, got away with the surcharge. And you know how that worked, obviously, that the trust would earn income, it would pay tax at the flat rate of 33%, capitalise the income, and then it would make capital distributions to the superannuitants tax-free in their hands because it had been taxed. And it was trust capital that was being paid out. So they were saving 25-30% tax on their cash flow. So, you know, those sorts of mechanisms are still valuable today, but not as valuable as they were earlier on. And then, of course, we have everything is a circle, isn't it? It goes round, or it's a pendulum. It swings backwards and forwards, where we have absolute liberty and then we have absolute restrictions, and backwards and forwards. And at the moment, we're probably about in the middle, where we're swinging back to more restrictions. We've had rest home subsidies, basically no point for trust these days. I've got an elderly classic story. Scottish woman, bear in mind what they're like with their money. They're quite tight with their money, all right? So I've got a Scottish woman, and her husband was suffering from incapacity, and he was in a rest home. And she applied for a rest home subsidy because it was not particularly helpful for her having her money draining out the bank account going to pay for the hospital. But she was denied a claim because she was just within that new enforcement regime where they're saying if you've transferred money to a trust, even if it was 20 years ago, the chief executive of the Ministry of Social Welfare would say, well, I consider you've done that with the intention of removing yourself from our purview, and therefore I'm going to look through all of your trust stuff and you have to pay. And she was incredibly, I guess I was not really excited, but when her husband died and the money wasn't running out anymore, she was somewhat relieved because she was denied the rest home subsidy. But she had the situation as well where, and again, this is an interesting situation. She had 2 children, and she was always saying that it was important for her that the trust fund was there for the family and to provide for the family and for the bloodline. And previously she had brought in daughters-in-law as trustees and things like that, and I said, well, that's quite counterintuitive to what you're trying to achieve. And one of her sons, both adults with families, one of them was dying of cancer in Australia, and one of them had substance abuse issues and was killing himself with that. And you know, she had her house and she had $1 million in the bank account, and you know, quite comfortable. And being Scottish, she wouldn't turn her heaters on during the day in winter and all that sort of stuff. And you know, she'd buy a little cutlet to last her for a week for a meal because she couldn't spend money on food and things like that. And I said to her, so just tell me, you want this trust to provide for your family? And she said, absolutely, in the times of need. And I said to her, so you've said to me you think you've got a good 5 years left, and you'll probably outlive both of your sons. Do you think this is the time in life where it might be a time in need that you could spend your money and perhaps go across and visit your son in Australia more than once every 2 or 3 years, and perhaps go across a few times and help them out? Yes, that's a really good idea. And I said, but you realise if you do that, it means that you won't have as much money left in your bank account. Oh, yeah, good point. And I said, don't decide now, but you just let me know in the next few days. And she came back saying, no, I need to have the money in the bank account. So, sometimes it's hard for us as lawyers guiding our clients, trying to let them know, if you set up a trust for a purpose, what is the purpose? And let's live up to that purpose. And sometimes people set up trusts because their friend at the barbecue had a trust, and although we can establish compelling reasons for a trust, sometimes clients aren't really being quite true to us about what they want. And it struck me that this woman set up a trust solely for the purpose, in hindsight, and it was with another firm years ago, obviously to get around rest home subsidies. And the rest of it didn't really matter because she didn't want the trust to have its true effect. So it's, again, the sands of time will change, and it's a question of evolving with that. I love this. Have you ever seen trust deeds from other practices or accountants or whatever where it looks somewhat familiar? Or sometimes you'll be looking at clauses and it says that the beneficiaries are, and it says at variable 2 because they've forgotten to cut and paste the variables in there, or they've got somebody's name in there, the wrong name. You see it a lot. I had a great example of a lawyer in the South Island who set up the trust during the days when he was using nominee set laws was quite prevalent, but he forgot to change his precedent. And the beneficiary, there was the set law, and he was one of the trustees, and the beneficiaries were the set law, and the set law's children and grandchildren, and of course the set law was the lawyer. And then when we looked at it and found out that had been going on for the last 5 or 10 years, and there had been distributions made to various parties who, strangely enough, actually weren't beneficiaries of the trust. So there had in fact been a breach of trust because funds had been paid out to people they thought were beneficiaries and hadn't actually gone to the lawyer and his family. This lawyer happened to be struck off as well, and far be it from me to comment, because you know what the little red books say, we can't make comments about our fellow practitioners that might be demeaning. But after discussion with them, the lawyer was amenable to signing a deed of modification and rectification to confirm there had been an error made. But those sorts of things, the danger of cutting and pasting can be a dangerous thing. And that whilst we all work from precedents, it's important that we don't treat the precedents as the gospel, because times change, circumstances change. And if you're anything like me with a moderate dose of OCD, you check clauses over and over to make sure the commas are in the right place, they get the right meaning, and that the right people are there, and that you can look at it twice and get the right nuances. It's important that we don't just ram, bam, thank you, ma'am, roll out trust documents, because they last for a long time and the problems can be quite extraordinary. Have you ever seen clauses that you've drafted by bespoke means come back at you in trust deeds? Yeah, I've seen that before. I think, gee, that's a good clause. I remember drafting that one a few years ago. Yeah, it is, but it irks you a bit. But it's par for the course these days. And I think what's going to happen is there's going to be a lot more scrutiny of trust deeds coming through. Just even without the Trusts Act, you're finding there are a lot more beneficiaries out there who are disenfranchised or aggrieved or feeling a false sense of entitlement. And then you might be acting for the trustees, and the trustees say, oh, I got this letter from such and such saying if I don't produce these documents, I'm going to be personally liable for all the costs. Have you ever received one of those? Yeah, it's interesting. I was at a seminar, it was the, it might even have been the STEP conference a little while ago, and I think Bill Patterson was presenting. You all know Bill Patterson? Yeah. And he was talking about the concept of disclosure of trust documents and things like that, and saying, the normal thing is you just fire off a letter saying if you don't produce the documents you're in breach and you'll be held personally liable, and you treat those with a grain of salt because they usually mean nothing. I thought, well, geez, Bill, that's a bit strange, because I got one of those from you about 2 weeks ago. And it's position heal thyself, isn't it? It's do as I say, not as I do. But that is going to become more of an issue these days. And we had that Rosewood and Schmidt case, which and was supported by Kane and Hutton, with Potter giving a pretty good dissertation of what's there.
Didn't the ERSEG case also lay out, what the trustees are obliged to give? Correct.
And ERSEG also highlighted the fact that there is a discretion involved because of family or commercial sensitivity. And that's going to be the issue where people will have a go at you. You say, oh, well, I think it's commercially or family-based insensitivity to release these details. And you can bet yourself it'll be brought up before the court, and the court will have to decide. But that puts the trustee in a difficult situation, because what happens with costs if you're found to have been wrong and made that decision incorrectly? technically you'd be liable for costs and not subject to the right of indemnity from the trust deed. But to me, again, there's a problem there because that is counterintuitive to the essence of a discretionary trust, where the trustees are there to exercise their discretion as they see fit. Now, there are certain levels they have to achieve in doing that. But what stops a judge from saying, oh, well, I think you should exercise your discretion this way? That's actually not what it's about. It's about the trustee at the time exercising their discretion, and would need to prove you've been through a process to establish the basis upon which you've exercised your discretion. And if that's the case, how can it be wrong? It can't be wrong unless you've done it with malice or bona fide, mala fides or something like that. So I think there's going to be a lot of room coming through. Memorandum of wishes, I think, will take on a greater prevalence. Do you, by way of straw poll throughout the audience, when you do a memorandum of wishes, do you have it signed by the settlors of the trust?
Yes, yeah.
I don't. I have mine unsigned on the basis that if it's not signed, it's easier to, or it gives you a better chance of arguing it's not a trust document, and that it's merely a confidential guidance note for a trustee, which is not part of the trust structure because it hasn't been signed by the settlor. Hasn't been tested, but to me, it's probably worth a shot if this is going to become an issue in due course. How can we minimise the potential exposure in that regard? So I try and keep it off to the side that way.
If you wanted it to be part of the trust document, though, but doesn't that sort of reduce its impact if you haven't got it signed?
Well, the essence, and again it's a grey area, the essence of a memorandum of wishes or memorandum of guidance, whatever you call it, is that it's a non-legally binding guidance note to the trustees, which is morally binding to the extent that unless there were compelling circumstances to the contrary, the trustees would be morally obliged to give effect to it. And obviously you can understand that because circumstances might change after settlers have died, which would think, well, giving this amount of money to a child as an annuity would actually be a bad thing because once the settlers died, they couldn't handle the grief and they had a chronic mental breakdown and became substance abusers, and to give them $100,000 each year as an annuity would be a bad thing. But for the beneficiary to say, well, I want to see the memorandum of guidance, it's said to give me this much money, you're not doing it. But the trustees would say, well, we have exercised our discretion and it's not in your best interest to do so. So, you know, it's a difficult thing. And I guess one of the things with trust law is it constantly evolves depending on what societal mores are. And you can understand that if trustees are being entrusted to own and manage assets for people with whom, and in respect of which they've got no vested interest whatsoever, and they're there for their objectivity and just to provide objective advice and to manage things for their best interests, why should we be subjected to courts saying, well, you should have exercised your discretion this way or that way, or, okay, I understand what the settlers wanted to do. And the settlers wanted to provide generally for their family and subsequent generations. And whilst they may have had some specific ideas as to how that could be achieved over time, they're relying on their trustees to manage that process and to assess the circumstances over time to see, is that still a compelling reason, or is there some other way that the trustees can meet the beneficiary's best interest as opposed to being a stickler to what was suggested at the time. So it's a grey area, and it'll be a litigator's delight, as are most of these things, when you're dealing with discretion. And what it means is that for the trustees, or giving advice to trustees, what evidence do you have that you've exercised your discretion properly? What have you taken into account? Can you establish somewhere that you've been through a process, you've assessed the facts, you've assessed the request for funds or whatever it is, and then made your decision based on those background details and arrived at your position, so that if you are called up before the court and they say that, you know, you haven't exercised your discretion properly, you can say, actually, well, I did. I looked at the beneficiaries and those two are fine, and this one here was in a really bad situation and it would not have been good to give them money because of this, this, this and this, therefore we declined to do so. And it's hard to see how that couldn't be sustained and said, okay, yeah, fair call. But are any of you do litigation? Yeah, they've got a different mindset. And so that's where the greyness comes through. So that's why...
I think also, I think the way things are going, it's, you know, that in the past, lawyers would just happily jump in and say, yeah, I'll be your professional trustee.
Yep.
It's like very, very compelling circumstances for us to say yes these days. Now it's like, it's so, the risk is so much greater.
Well, again, it's an evolutionary thing. Older practitioners, and I'm putting that people above me, because I'm just a young old fellow. It was a gratuitous thing as a service to your client. Oh yes, I'll be your trustee. And in most cases, they were fairly passive trusts and there wasn't much attaching to it, and the children were all well trained and there wasn't much trust litigation around, and what a trustee said went. In fact, I remember when I first came here in '93, and when we were doing trusts then, I could guarantee to clients that it didn't matter who you had listed in your class of beneficiaries, unless and until the trustees exercised their discretion in favour of that beneficiary, they had no right other than to ensure the trust was properly administered and that beneficiaries' interests were considered. You can no longer give that guarantee because of all the social nuances.
So sitting on the other side of the fence, I've had people, friends, etc., who have rung me up and said, by the way, I've given your name and details to our solicitor because we're setting up a trust, and they're going to send you the documents. And I've then had a conversation and said to them why I'm not prepared to be a trustee. And I've actually had documents arrive in my letterbox, and no solicitor has rung me prior to them putting them in the mail to have a conversation with me about what my liability, and it says sign here. And that just blows me away, because I wonder how many people in New Zealand have just signed here and taken it as a compliment that someone's actually asked them to be a trustee on their trust.
Absolutely.
And I think that's going to be huge in the future as well, as people begin to see certain circumstances play out.
I think there are, that's a very real point, and I think there are two root causes for this. First one, have any of you ever seen the movie called The Castle?
Yes.
Can you remember the conveyancing solicitor, Danny Denuto, appearing before the federal court, and the judge asking him, well, what's your reason, Mr. Denuto? And he said, well, it's Mabo, it's the vibe. And sadly, I think a lot of what happens in our system is vibe-based. Oh, it just feels like we should do that. We should give them some money, or we should give them a right or something. There's a lot of that. And it's, I don't know how to comment without being too derisory, but to me, that's what's happening, is that we have a social justice system, and I have to remind clients that we don't actually have a justice system, we have a legal system, and invariably it's he who has the deepest pockets who gets the best law. So again, that's my cynicism coming out, but I think I see that too often. And I think the other problem is Stephen Tyndall of the Warehouse, who has convinced an entire nation that everybody gets a bargain. And people are not prepared to pay for proper advice these days. If you want to get something done properly, you pay peanuts, you get monkeys. Or is it? You pay monkeys? Yeah. Whatever it is, you know that what I'm saying. You can't expect somebody who's doing a job really cheaply to provide quality. And I think I saw a saying once that you can have, there are three sorts of work we provide: fast, good and cheap. But you can only have two of them at once. You can't have all three at the same time. And I think that's right. And I usually don't go for fast, because my view with trust is that it's hard enough for lawyers to get their heads around it. And I'm sure I'm not being too demeaning to my fellow practitioners, but a lot of lawyers don't really understand the nuances and subtleties of trust. How on earth does a layman understand them? And if you're saying if a client says, oh, I'm buying a property and, oh, settlement's on Friday, I need a trust to buy it. And often we get instructions from our property team or something saying this is what's happening. I say, well, I can't do that. I'm not just here to put in place a trust just to buy a property. I need to understand what's the reason for the trust, what are the family circumstances, what are the issues, what are the potential liabilities, what are the claims, what are the overall circumstances, is this correct, should it be an LTC, should it be a company, should it be a mirror trust, should it be a parallel trust, should it be a dual trust structure? I can't just do that. And they'll say, but we just need a trust for settlement. And it's that lack of understanding. And then to have a client come in and say, okay, today is Wednesday, settlement's Friday, we're going to have to come in tomorrow, sign, I'll have to work till 2 o'clock in the morning to get your trust deed organised. And it's not just pushing a button and putting your name in, there's actually a bit of work involved in doing that. You'll have to come in tomorrow, first thing sign it, so we can then apply to the IRD to get your tax number, so we've got to complete the land tax statement, sign the documents, who will be your independent trustee? Oh, I don't want an independent trustee. Do I have to have one? Well, at law, no, but it's my recommendation you have one. Well, why is that? Oh, no, don't worry, I don't want one. I say, so do you understand about trusts? Well, not really. So how are you going to run your trust properly? You know, each little step of the way leads to problems, and we get dumbed down all the time. Do you guys, what are your thoughts on independent trustees? Do you use independent trustees?
Yes, but like you say, you get a lot of pushback,
Yeah.
and sometimes one of the ways we've overcome that is to say, well, if you don't want to take that recommendation, perhaps we incorporate a trustee company,
Yeah.
and you know, then if you come down the track, you change your mind, you can then bring in a professional, but
If you incorporate the company, who do you have as the officers of the company?
well, yeah, typically sometimes it'll be one of the settlers, or you know, but they're all different. But I mean, that's one of the. It's not a satisfactory solution.
Yeah.
I mean, yeah, you get big pushback.
Absolutely. What about the rest of you?
Possible.
What are your thoughts? What are your practices? Do you have independent trustees predominantly? Do you recommend them? Do you optional? What are your thoughts? Up the back there. What are your thoughts? What's Perpetual do?
Well, we often have Perpetual as a trustee
Yeah.
of trusts.
Yeah, and that's, in one way, institutionally, you're an advantage over most of us, because people know going to the public trust or guardian trust of Perpetual, that's how they operate. They are the trustee and they're involved. So in a way, that takes out the question. And they never ask the question, well, why are you the trustee? You go to Perpetual, that's the way it is. But when they come to private practice, what's your experience?
We recommend,
Yeah.
and typically a trust company or an independent trustee, in the third fallback position is, you know, often they don't want anyone. And I guess part of that is looking at the situation and saying, look, you're going to get some pushback.
Yeah.
Looking at the family situation, there's going to be pushback. You need somebody independent who's going to be able to stand up and respond to those beneficiaries pushing. And it's far easier for an independent trustee to do it than try to destroy a lot of the family relationships.
Yeah, absolutely. What about over here? What KS, what do you do over there?
Yeah, we recommend independent trustees as
Yeah.
well, especially because like the administration of a trust is like we get clients coming to us that have a trust but have no idea what property is in the trust, or have a lawyer from 10 years ago as their trustee but they don't even know if that lawyer's still alive, or you know, like so in terms of administration as well.
Yeah. It's actually a very real issue, and Trust Administration Module 2 touches on that. But I think what I've found is, again, it's a bloody Stephen Tyndall, everyone gets a bargain. People think they can get a trust, you know, off the shelf sort of thing and park it away and they're okay. A lot of people say, oh, well, look, I'll use a family member. And I'll say, well, your family member probably can't be independent because you've got them included in your class of beneficiaries. They say, oh, well, what about a family friend? And I say, well, are you comfortable with your family friend understanding all of your personal and financial details? Do they need to know that? Yes, they do. Okay. And okay, if you're comfortable with that, what does your friend do? Oh, he's a bricklayer. Okay, that's cool, and I know you trusted him implicitly, but does he know much about trust law? No, but does he need to? And people, they want the cheap option all the time, and you say, look, and what's happening these days is it's changing. If you want to have a trust, you've actually got to want it. There's got to be a good reason for it, but you've got to pay for it. Because there's no sense having the best thing in the world when it's signed up, only to have it fall over once you start disadministering it. I'm not sure that's a word, but I quite like it.
That's why I wonder whether that in the future there is going to be this opportunity for deep-pocketed corporates that provide a really high-level trustee service, because I think there's, you know, it's just, you actually, you know, as we've said, we can only outlay the best practice, but, you know, all the things you've just said about, you know, lack of a person who you want to know your intimate details of your financial life, makes it quite difficult.
There are two obvious choices. It's your accountant or your lawyer. And accountant, as long as they're savvy and up to speed with things. You don't want a little backroom accountant at the back of, I don't know, Bombay or something who does all their bookwork and things and bookkeeping. You want somebody who's actually doing some business advisory services and things like that. Personal trustee, do you accept personal trusteeships?
Less than that.
Yeah, you see, we used to, and that's the old legacy, we used to, but not anymore. And then we went to corporates. Do KS use corporate trustee?
We've got corporate trustees, but
One company for all the trusts, or what do you do?
no, there's
I'm not asking you to give away trade secrets here.
no.
I've done my company searches, it's all right.
There's a few.
Yeah. But I think that we were all reminded after, I think it was the Newmarket Trustees case, that having one corporate trustee doesn't cut the mustard because there are some severe risks. And given that it's so cheap to form a company these days, our practice is if they want us to be a trustee, we'll do it, but we do it via a corporate trustee, standalone company, one company per trust.
Yeah, that's what we do.
Cost to the client, and there's a first up fee in the first year, which covers being a trustee plus all the incorporation costs, and then each year thereafter there is a fee for providing the corporate trustee, which is a flat fee plus gist and disbursements for providing the trustee. Any trustee activity is usual time charge basis. And that helps to weed out clients who are legitimate about what they want to do in their services, because if you want us to be a trustee, well, you've got to pay for it. Who calls their lawyer and expects not to get a bill from it? That's what we're there for.
You become the director of that company.
And so what we do is we have several partners of the firm who are directors of the company, and we have a holding company or a nominee company of the firm as a shareholder. So it is completely independent. So many times I have seen trusts set up with independent trustee companies where you do a search of the company and the directors and shareholders are the settlors. Where is the independence? Even though a company has a separate legal entity, when you pierce the corporate veil, there is no change.
What I've struck, and I've had some clients that were very angry when they discovered it, was that there was a clause in their trustee that said that they had to have an independent trustee, and that's all fine. So, and that at all times there had to be this independent trustee, but then you couldn't get rid of that clause either when they actually wanted to resettle.
Right.
And actually, because they were the scenario you just talked of, where they'd got to the end of their, they're elderly, they really don't want to have an independent trustee anymore. They've actually been very good at operating the trust themselves and can't get rid of an independent trustee.
Right.
So they're stuck with it, and it's, and of course if we resettle into another trust, they were up for tax issues,
Yes.
so they were very angry when they found that out. So I think lawyers undo themselves a wee bit with that kind of thing, where you're sort of forcing that on them. If you're upfront with them and explain to them and the benefits of having it, I find
Well,
that.
and I think that comes back to the education aspect. If a client's coming in because they said yes, they want a trust deed, and you roll out your normal format, and they just sign it because they've got the trust in place, they don't understand what the nuances are. When I see clients to sign trust documents, it takes about an hour and a half because I go through each clause of the trust deed, having explained it in a 16-page letter previously. This is generally what happens. This is what this clause says. This is what this one does. Then they've thought about that for a while and come back with questions. And I always know if they've read the trust deed because there's always one question they ask. And if they don't ask the question, I can say, you haven't read the whole trust deed, have you? No, because I can tell. But you talk it through. And I make a point of explaining in my explanatory letters about trustees. There is no requirement at law to have an independent trustee. However, it is my recommendation because from best practice, it shows an immediate change of legal ownership, which is your first step. And then that itself won't solve your problems because if you just have a dummy there, what's the point? You've got to have a robust trustee who will work with you and understand your objectives or whatever. And you've got to administer the trust properly. So there are lots of issues that come with it. Why don't we have a quick break before we roll on to the next part? Let's have about 5 minutes for a coffee, water, toilet, cigarettes, whatever. Well, if anyone's doing drugs, I'd have to say don't do it. It's not good for you.